So welcome once again. I'm Mike Pothier. I'm the Program Manager of the Catholic Parliamentary Liaison Office. We are co-hosting this event with Freedom Under Law. And you also see behind me the banner of the Hans Seidel Foundation, which is sponsoring the event. We also received sponsorship for this from the Millennium Trust. And our other partner this evening is News 24. This will be recorded, edited as a video, and will be available later on the News 24 channels, also on the websites of the co-hosting organizations. With me to discuss tonight's topic, as you know from the program, we have 4 panelists. They're not going to give a speech or a talk. They're going to give, I hope, fairly concise answers to some questions and then engage in a conversation about the topic. So we have Judith February, the Executive Officer of Freedom Under Law. Next to me, Mbekezeli Benjamin, the Research and Advocacy Officer of Judges Matter. On my other side, Karyn Maughan, legal journalist with News 24, and I think fair to say not one of Jacob Zuma's favorite people. And then next to Karyn is Professor Hugh, whom I'm sure most of you know, Professor of Public Law at UCT. So those are our 4 panelists. I'm going to start each one of them off with a prepared question. We're here to talk about the recent impeachment of 2 judges. And as we've kind of built it, we can look at the glass half full and say this is an important constitutional milestone. Certain processes have been undertaken, albeit extremely slowly, but they have worked, and a result has been obtained through process, through the rule of law. Or we could see it as a glass half empty and say that this is a disaster. It's a shameful thing to have happened. What a pity. And what are we going to do about it? I'm hoping that by the end of this evening, we will maybe decide which of those 2 impressions to take away with us. And I'm going to start by asking Judith what these impeachments mean for the judiciary as an institution, for its reputation, for its public standing. Does the fact that 2 judges have been impeached diminish the stature of the whole institution? Or can we say, rather, on the positive side, this is something that has really affirmed the strength of our constitution and of our constitutional processes?
Thank you very much, Mike, and hello, everyone. As usual in South Africa, the answer is we're somewhere in between, I guess. And I'd be interested also to hear the other panelists' views. But I want to just offer, I think, in answering that question, just a few comments to place these impeachments within a particular context. And with regard to that, I think I want to refer to 2 surveys that were done. The first one is the Afrobarometer survey, which was done by the Institute for Justice and Reconciliation. And that is around the trust that ordinary South Africans have in our judicial system. And rather worryingly, and this is the latest survey, 53% of respondents said they trust the courts just a little or not at all, and 43% saying somewhat or a lot. And there has been a decline, Mike, since the 2011 survey that was done. And this, in fact, also mirrors the numbers from the South African Reconciliation Barometer, which paints a very gloomy picture of South Africans' perceptions of the judiciary. And so it happens within that context. And I want to just read a quote from the Reconciliation Barometer. It says, "Never before in the course of the 2 decades of the barometer, we found such profound distrust in leadership, coupled with little confidence in the critical public institutions that form the foundation of a functional democracy. South Africans have endured years of state capture, and most remain deeply concerned about the consequences of corruption. there is widespread belief that perpetrators operate with impunity as well as doubt over the political will required for change. Now, of course, there are different reasons why people answer this, and one doesn't want to get into that. But I think the context of this is that we have also had a decade of state capture, a decade of the erosion of our democracy and the hollowing out of state institutions. And of course, the recovery from that, we're still busy understanding how hard it is, how almost easy, and this is, it's hard to say this for those of us who were around in the 90s and before, how almost much easier it is to build an institution than to keep it going, but to build it up after it has been destroyed. And we see that quite graphically with regard to the NPA and indeed our parliament. And on that, I'd like to say that, of course, the preliminary step, the vote on impeachment, was done within Parliament. And of course, Parliament in and of itself, an institution I followed for 20 years plus, which has also been denuded of some of its authority and also its oversight role eroded. But yet, and in South Africa, this always seems to be an and yet it was, we had the impeachment of these two judges. And that has something to do with the mixture of a robustness within our institutions, which despite the fact that some of them, that they have been denuded, that within the judiciary, that there seem to be in South Africa, these pockets of robustness, these pockets of resilience that simply keep the system chugging along. But also I think that there's been a change in the political tea leaves from the time that Judge Hlophe, that these complaints were brought against these judges. And it's taken an awfully long time. And I'll come to that in a minute. But the other context here is a global context. And if we look at the 2023 World Justice Project Rule of Law Index, which notes the continuing recession of the rule of law. And as David Miliband has talked about the pandemic of impunity, which is rife around the world. He was writing in the context of COVID-19, but that has an impact on all institutions. So it's against that backdrop that we're having this conversation, and a very difficult one, and particularly with Parliament behind us, where the Speaker has resigned. And one can also say, is this a good or a bad thing? And that's for another time. But I don't think we can underestimate the impact that almost a decade of state capture has had on South Africans, on our perceptions of these institutions, but also on the reality of how they actually work. And then, of course, Mike, and we will get into this, I'm sure, with our other panelists, the actual process, the protracted nature of these processes, and there's been a lot written about Stalingrad and the way in which the legal process has been abused by people in power to simply dig their heels in. And this, I think, does not help people's perceptions of the system and their perceptions that there are certain people who are powerful, who can buy the best lawyer, the best, or one might say the not so good lawyers, but the ones who have the ability to use every single sort of defense in the playbook, and how people have been able to just provide that solid defense. And so people think that, you can get away with it. Jacob Zuma is walking around largest life, although he was meant to be medically paroled. So this does not have a good impact on the way in which people view the judiciary, and the perceptions are influenced by those factors. But lastly, I want to say, because I know we will get into this more, but these complaints have taken so long, and certainly in our work, Freedom Under Law's work on the Judicial Service Commission, and doing a retrospective on its work, we have written extensively on the complaints process and how that could possibly be streamlined, and how that can be put in, better used so that you don't have a situation like the Hlophe and Motata matters, which have simply gone on for far too long. So there is a space here for judicial reform, which I think is a silver lining in this. But the last 2 points I want to make is that what we have had is, and freedom under law has been part of this litigation, particularly with in Hlophe and Motata matters from the start. And I think what it does show is every step of the way, it does show that if we don't have a vigilant civil society, if we don't have a vigilant media, if we don't have discussions like these, well, our democracy will be poorer for it. And all of us who've been involved in this kind of work, it really is the work of exhaustive pursuit. And so we have to keep going, despite the fact that things may look quite bleak. And, you know, in 2009 or wherever it was, with all the defenses that were put up, that things, you know, one would imagine that if you had said, well, you know, the outcome of this is going to be in 2023, well, people might have thought differently about pursuing it. But I just want to end my opening remarks with a quote from Justice Michael Kirby, who's actually on our Freedom Under Law Advisory Board. And he was intrigued by this impeachment, this historical impeachment of 2 judges in South Africa. And I said, well, it's taken so long and, you know, we've all thoroughly exhausted by it and there's he wrote to me and he said, Judith, at least your constitution worked. How many other states could boast of that in such a sensitive area? And so I think if we are feeling, you know, as if things are all falling apart around us, is that there are these pockets of resilience and robustness. And those are the ones that we need to work at, and we need to keep pursuing in the common good, and so that we do actually meet the requirements of the Constitution. Thanks, Mike.
Thank you. Mbekezeli, Judith has mentioned the role of the Judicial Service Commission. You watch that organization possibly more closely than just about anybody else in the country, I think. How do we assess their role in this? Again, it could be different things. Just another example of how some stuff takes forever to happen in our country, especially if it's anything to do with courts and judges and lawyers. Or was there manipulation? Was there political play going on behind the scenes to delay the process and hopefully sweep it under the carpet and make it go away? What is your take on that?
Thanks, Mike, and good evening to everyone who's joining us in person and online. And thank you very much for taking the time. Well, Michael, I'll start with answering the last bit of your question, and then I'll work backwards. Was there political manipulation to ensure that this process doesn't work? I'm not convinced. Did this process take too long to reach the conclusion? Absolutely, yes. And the reason is not entirely Judge Hlophe's fault, surprisingly. First of all, when these complaints were made, right, let's recall, Judge Motata was accused of driving drunk and into someone's wall, and then he made very unflattering remarks. Some of it was found to be racist remarks towards someone, and sexist remarks also towards a Black woman. So we must remember that. Those were serious allegations against the judge, and there wasn't even a system to deal with them. We must remember that at that time, the judiciary was basically a buddy-buddy system, and that was much easier to enforce the unwritten rules because you simply needed to call someone in and speak to them. And so back then, it wasn't ever imagined that we actually need written rules. We need a system to ensure that we enforce these rules, and we need to put resources to ensure that the system works. So at the time that these complaints came out, there wasn't a system to speak of. And so that's why initially we saw the time that it took for the complaint against Judge Hlophe to be dealt with, the time that it took for Judge Motata's complaint to be dealt with, that was a bit of time. But what made the process even slower and took up the biggest chunk of the last 15 or so years was the in and out of court, which wasn't actually because of Judge Hlophe. He was just sitting and riding the wave. The people who were going in and out of court to drag the system down were the two complainants, so to speak. Two justices, Justice Jafta and Justice Nkabinde, who were the ones that Judge Hlophe flew from Cape Town to Johannesburg to try and influence. And then those two challenged, firstly, the rules when the rules were set up. When they failed to challenge the rules, they challenged the procedures. When they failed to challenge the procedures, they went all the way to the Constitutional Court and back. Each and every step they failed. So when they lose in the High Court, they'll appeal. When they lose in the appeal court, they'll go to the Constitutional Court, to the point where the Constitutional Court was conflicted and they couldn't deal with their cases anymore because they've dealt with that so many times. And they said, no, we can't deal with this. This has to be resolved elsewhere. And that's when the JSC woke up, decided to rewrite the rules and have a proper system in place. And again, and this is where we must give credit to Freedom Under Law and the team that Judith leads. They made sure that at each and every point, there was a civil society voice that tried to revive this. That they took it to the judiciary, they took it to the Supreme Court of Appeal, which was the one which said, no, the JSC needs to create a proper system to deal with these complaints. So that kind of background sort of fades into away from our memory sometimes when we're assessing how long this process takes. So there was definitely that delays. I don't believe that there was political manipulation. I think it was just incompetence on the part of the JSC. I wouldn't give them the credit to say they were cunning enough to manipulate the system. They're just purely incompetent. And so when we assess that JSC and where we are now, and this is where I get to the first part of your question, I think there's been some progress. Look, the Hlophe and Motata cases, I think, were a low point for our judiciary. I don't think anyone in 1994 envisioned that a judge will one day be impeached, and which is why I say there wasn't even rules to regulate it. But we are where we are now, where we know that there is accountability, even for the most powerful in our society, which are judges, and often they see themselves as untouchable. So this time around, we know that judges are actually accountable. We know that the system to hold them accountable exists. What I can say is that it's not effective enough still. There is a lot of progress being made. We see complaints move a little bit faster than they used to be in the past. The system already exists. We just need reforms to the system to make it work better. And those reforms, including just giving it proper resources, making sure that the processes are quite clear. And this is the point that Judith made earlier, that the current processes are so complex and so convoluted. Even the members of the JSC themselves don't know how they work. So we need those processes to be streamlined so that we get more complaints dealt with as speedily as possible. So in conclusion, I like to see the glass as half full. Our judiciary has remained strong, and the World Justice Project that Judith mentioned gives us that credit. The Afrobarometer survey, yes, did say that the decline in the trust in our judiciary has gone down, but the judiciary still remains as one of the trusted institutions in our society. What we need, and this is the challenge that all of us, not just those in civil society or business, including those at the JSC, is for us to make the system work better. And that's part of the reforms that I think they should get ahead with. So the answer is, the picture is a glass half full.
Thank you very much. That's good to know. And we'll come back a little bit later to what might be confronting the JSC quite soon in terms of further possible impeachments and complaints. Hugh, I want to come to you about the historical context. There's a kind of myth that goes around, I call it an anti-transformation myth, that says in the old days, judges were all of unquestionable integrity, very, very capable people because they came up through the ranks of the bar, of course, and no scandal ever attached to a judge in the old South Africa. You wrote and I'm sorry to say it's 40 years ago that you wrote in your book, The Judges at Work, about the aura of infallibility, which in the eyes of many observers surrounds the South African judiciary. I suspect that behind that aura, some of them were just better at hiding their fallibilities. And as long as they didn't rock the boat, the apartheid boat or the colonial boat, they were left alone. Is that a fair judgment?
Thank you, Mike, and thank you for this opportunity. It's lovely to be on a panel when you're immediately thinking to yourself, well, that's not actually quite right what has been said, not by you, the chair, but by my two predecessors. So I hope we'll have the opportunity for some vigorous debate. Let me start by saying the following, because I think it has to be said, and it has to be said repeatedly. This is a tragic moment in the development of our constitution. That two people, one of whom I know quite well, Judge Hlophe, who promised so much at the time of his appointment at a very young age, has ended up by being the first person in the history of this country to be impeached. So for me, it's a tragedy, but at the same moment, it is an indication of the robustness and, to a certain extent, in one aspect at least, the coming of age of our constitutional democracy. That despite all the delays, some of which were caused by Judge Hlophe going to court as well, but myriad others, that we are where we are today. It's not a time for celebration. It's a time for reflection. Okay, to talk about the apartheid and colonial past, I think you've summarized it well, Mike, in what you've said. The track record of the apartheid judiciary, although nominally independent, was overwhelmingly racist in its outlook. It shared a common set of values with the people who were in parliament, almost all of whom were white men, and all of the judges were white men, bar one, until the last year of apartheid, when Justice van den Heever was joined by Justice Traverso here in the Western Cape to produce 2 women out of 164 people on the bench. And by that stage, there were 2 Indian South Africans who joined them on the bench as well. During the 70s and the 80s, the judiciary also became increasingly executive-minded. So not only were they unquestioning of the motivation of acts of parliament and the meaning and the impact of acts of parliament, but they were giving the executive much more latitude. Now, of course, that was in a situation of parliamentary sovereignty, but the inherent malleability and indefinition of language provides the scope for judges to seek to uphold the values that I would argue are part of our common law, both in Roman Dutch and its English variety, which they were implementing. So there was scope, and there were examples where the judiciary upheld individual liberty and the basic values of the Constitution against what was coming out of the institution just behind me to our left, and also what is now 120 Plain Street, where it used to be the HF of Work building where the executive was sitting. Critical were appointment and accountability, methods of appointment of judges and accountability. It's critical again today. We've got to get the appointments right. If we get the appointments right, we don't have to worry about the accountability, bar perhaps a couple of aberrant cases. In the old days before 1994, judges were appointed by what was called the tap on the shoulder kind of thing. The Minister of Justice would consult informally with the existing judiciary and the leaders of the profession. A name would come up, they'd check him out, and if they thought he wasn't going to really badly rock the boat, then the person would be appointed. That was the pattern overwhelmingly from 1910 through to 1994. At the time of the accession to power of the National Party and the apartheid regime in 1948, there was a sea change. Many really deserving white men at the bar were overlooked, and people were fast-tracked. Afrikaner nationalists were fast-tracked into the judiciary and positions of great authority. And Lucas C. Steyn, our Chief Justice from 1958 onwards, was somebody who in 1950 hadn't even been a judge, and then he became head of the judiciary 8 years later, promoted over the much more deserving causes of at least 3 other appellate judges, most famously Justice Schreiner. But there were other examples. There was a former Attorney General of the Cape here, Bram Lataghan, who became a judge in 1980 after the service on the Information Commission, the Commission into the Information Scandal. Let me then quickly move to accountability. There were no mechanisms to hold judges accountable in a formal sense, other than if you were guilty of gross misconduct or gross incompetence or basically losing your mind, then you could be dismissed by a resolution of the National Assembly and Parliament. No judge in the history of this country, except for 1897 in Kruger's Transvaal Republic, the ZAR, where Chief Justice Kotze and 2 of his fellow judges were dismissed by Kruger for introducing what was called the testing right. Bringing the devil into the Garden of Eden was Kruger's analogy, because they questioned a resolution of the Volksraad in 1897. But since 1910, none. And I think it is fair to say that there was never any public knowledge of anything like receiving extra income from an asset management company over several years in the hundreds of thousands of rand, nor I think there probably were judges who drove drunk, but none of that was in the public domain. My last point in my first little essay now is that the bottom line, there was also manipulation of judicial appointments. Chief Justice Rabi continued beyond the retirement age in the mid-80s during the state of emergency because the apartheid government did not want to appoint Justice Corbett as Chief Justice. And they wanted a safe pair of hands to get the same appellate judges hearing the same challenges before to the state of emergency under the state of emergency. Last point, and why we must take heart from this incident is that in the Constitution, Section 1C, one of the fundamental values is that we have a system of participatory democracy that values accountability, responsiveness, and openness, ARO. And those have been absolutely, after a very long struggle, reconfirmed by these 2 impeachments. And from that, I would argue, we must take heart. Thank you.
Thanks, Hugh. Karyn, your turn. It's already been mentioned that the media and civil society played an important role in keeping this whole question alive when there were clearly attempts to let it die out quietly. We have a sort of natural sense of deference to the courts and to judges, which is very different from the way we respond, for example, to politicians. You report on the courts and the judges and so on. How difficult is it to maintain, I suppose, the necessary deference and respect for the judicial office, etc., and yet at the same time get to the truth of what's happening? How have you found that in your reporting on these and similar issues?
I think one of the biggest issues that we have at the moment as society, and I don't think we can underestimate it, is the level of misinformation that's out there. And it's a global phenomenon, right? Like any major news event, there's going to be a whole lot of fake content, whether it's a war or a business issue, or whatever it is, that will literally make it very difficult for a lot of people who don't necessarily engage regularly with the news to be able to discern what's going on. And the judiciary is no different. And part of the problem is that I think the media has become very scarily dependent on social media for stories and for insights and for angles. So you will go to a press conference with the Chief Justice and someone will put up their hand and ask him, is the judiciary captured? Like that's a question. And, it irritates me because Chief Justice Mogoeng, who the former, who is someone that I also blame very heavily for what happened with Hlophe, because he protected him for a very long time on a basis that was completely, inappropriate. The issue of him not having legal fees for 2 years, that thing didn't go ahead. But he said, and I think as media, as anyone, he said, we as the judiciary don't have a problem with criticism, just be specific. And rather than being specific, we have this culture with people like Julius Malema, who God knows why is on the JSE, but he's there, posting so-called fake intelligence reports and saying that this is evidence of judicial capture, when the most basic 2-hour search by journalists reveals that it's a fake intelligence report. It's written by an AIDS dissident who is extremely upset with one of the judges that he names as being corrupt. And, even the most basic research would illustrate to you straight away that this story is not true. But there's a host of bad actors, including, and I would say the EFF is very much part of this, that don't accept judges who rule against them. And I think Malema, for me, is one of the biggest threats to the safe functioning of the JSE, because he goes after judges and has been enabled to go after judges in highly politically complex cases. In one incident, he went after Motata after he ruled against the EFF in that case with Trevor Manuel. So we have this open season on judges who can't defend themselves. You can't come out there as a judge and say, that's not true. I didn't get 50 million rand from Cyril Ramaphosa, because that will become the headline. And you shouldn't have to do that. It shouldn't be something that we just have this culture where that kind of nonsense just gets repeated and then gets sucked into a media that in many respects has, doesn't necessarily have the discernment that it needs to have in terms of making active choices about fact checking and not amplifying misinformation. I think I feel very passionately about it, because when you get falsely accused of stealing someone's medical records, when you use court papers, and that story ends up being amplified in the media, you realize how scary this is when it gets turned on you, and how that stuff will get repeated and repeated and repeated like it is fact. So I think that I think the misinformation campaign against the judiciary has been very manifestly determined and pointed. And I think that we as citizens and people who engage in the media need to be very careful about what we consume, and also push back when people are saying things like such and such a judge is corrupt, he's on Cyril Ramaphosa's payroll, et cetera, and actually say, what's your evidence for that? What's your evidence? People have a right to be cynical in South Africa. We come from a very dark past, and we have a lot of reasons in the state capture era to not want to necessarily just believe authority. But the reverse also has to be true. When people make conspiratorial allegations, I don't know what that word is, allegations against, the judiciary or whatever it is, ask for the evidence. Like, say, what is your basis for saying that? That's what I always do. I think the fascinating thing for me and with Hlophe and Motata was the disinformation that when around the time of the impeachment, where Hlophe literally went on a TV interview and said that he was being removed from office just for having a little academic debate amongst 2 judges. We all do this. And, there's a finding made that says that's not what you did. You went and targeted the judge who was writing a note on privilege, and you initiated a conversation with her, and you said, quote unquote, Jacob Zuma is being persecuted just like I'm being persecuted, and the SCA got this issue of privilege wrong. And I know intelligence authorities and many judges are going to lose their jobs when Jacob Zuma comes into power. You didn't have an innocent conversation. But, Hlophe's supporters will reincarnate that and say, he's just being persecuted. Hlophe had 10 major scandals before he was finally removed from office. And the worst of them was Oasis. He was getting paid by a consulting company while serving as a judge. And he came before the JSE, and the JSE dismissed that case on the basis that he'd asked permission from the now, fortunately for him, deceased justice minister to get that money. A judge getting money from a consultancy is absolutely unacceptable. That's not something that you can do, but he got away with it. The final thing that led to his impeachment, while he's also facing an impeachment, well, was facing another impeachment tribunal for his conduct towards Patricia Goliath, was actually one of many things he stood accused of. And so in this desire to rewrite history and to cast him as some kind of wronged hero, again, misinformation is put out there to actually diminish what he did and the seriousness of it and the threat it posed to a constitutional democracy. And that's why when we engage with these things, we need to know the history of them. And we certainly can't accept, certainly not from politicians or anyone else, that we're getting the true story when they're presenting simplified versions of what happened, as if that is an excuse for them and why they should not have been impeached.
Thanks, everyone. I do want to try to keep it as far as possible on a broader level than just John Hlophe and not to focus too much on one individual. But obviously, he's the kind of leading candidate in all of this at the moment. So, apart from 1897, when for political reasons, Kruger kicked out a couple of judges, no judge ever, of all the hundreds and hundreds that have served, was impeached or removed from office until a couple of weeks ago. And now we have Judge Nana Makubele facing inquiries based on the fact that she was chairperson of PRASA after she was appointed to the bench and didn't resign that office. And there may be a couple of other complaints against her as well. That's being dealt with by the Judicial Conduct Tribunal at the moment. And then even more recently, Judge Chifiwa Maumela in Gauteng has been suspended. He was suspended in June last year on the basis that he has a huge number of very long outstanding judgments, and he wasn't able to give his judge president a satisfactory answer as to when he would get them done. And his inquiry has been postponed because of illness on his part. So are we starting to see some horrible trend developing here? It would have been lovely to say Hlophe and Motata was just an aberration, never going to happen again. And lo and behold, here come two more around the corner. Mbekezeli, is this a trend or are those going to be the last two?
I wish I can say they were the last two. And in fact, I would be very happy if I never ever have to sit in a tribunal again. But look, we have to face the reality that judges are not angels. They are human beings. And sometimes they do make mistakes. They are fallible, and which is why we need to have proper, rigorous systems to hold them accountable when they fail to meet the standards that we should always hold them to. So the argument is not that we should ever be lenient towards judges. We should actually hold them to the highest standards because of how much power they wield in society. But what we are seeing right now, and the ones that you count, are actually sort of, the one is quite serious because the judge is accused of involving herself in what could easily be furthering state capture and corruption. The other one was just purely incompetent and just couldn't do the job and should have been dealt with much earlier. There's another one coming up which you didn't count, another judge who's facing a tribunal for sexual harassment. And that, he's facing the judge president, a very senior judge. He's facing sexual harassment as the only judge who is facing that. I don't recall an advocate ever being prosecuted for sexual harassment, even though we know studies have shown that it is pervasive in the legal profession. And so what we're seeing is the system actually being responsive, holding these people accountable. And for a very long time, that hasn't been the story that we could tell. It hasn't been a situation where complainants feel emboldened enough to come forward with their complaints, that the JSC would actually take it seriously enough to say, look, this needs to go to a tribunal. Because as Karyn and probably Hugh said earlier on, is that some of why these complaints never went far is because there was every attempt to try and actually sweep it under the carpet.
Yeah.
If they could find any reason for it to be swept under the carpet, they definitely would. But now we're seeing them actually go through proper processes of investigation, of prosecution. And in fact, what we are unfortunately seeing is the judges themselves actually use the methods to try and stall the process. Like if you look at the tribunal for Judge Maughan that we've sat on for close to 2 years now, she's literally tried every trick in the book. At one point, she just said, my tire burst. I went to the wrong venue. I came late because I couldn't. So those reasons are sort of really rubbish reasons for stopping a process that should hold you accountable. We should expect better. But the story is, and the story we must keep telling, is that they should be held accountable. Whatever delays that you are causing, we are not going to relent. We are going to push hard and hold you accountable. So the answer to your question, Mike, is that, yeah, we might see more cases. And now we are seeing quite a number. But I think things will be a little bit worse before they get better.
And just one of the more important ones is obviously that one, the arms deal inquiry, where, you know, Judge Willie Soretti, and I think that, I'm not forget the other judge's name. It's been brought, yeah, yes, because they've been brought before the JSC for essentially conducting a whitewash investigation into the arms deal to the tune of over 100 million rand. And that's, I mean, I think when that thing starts actually running, it's going to be significant.
So just, sorry. So just to bring it back, I mean, to the issues around the information that we have in the public domain right now, and because I think the points, Mike, that you were making at the beginning around the role of civil society and then also the role of the media. But I mean, I can't tell you, I mean, Karyn, you referred to that report by the AIDS dissident that was put online. I can't tell you how many calls I got from journalists who immediately saw it and then wanted a comment. So there's no time between seeing it to read it and then to think about it and then to make a comment. But, you know, so that's, as you say, is part of our problem. Don't get sucked into or buy into that misinformation. And there's so much of that around. Just because it's tweeted doesn't make it true, right?
Exactly.
So, but we do have, at the same time, it's a double-edged sword, because we do have more information now than we ever have had. And I think that is part of the open democracy that, you know, Hugh mentioned in the founding sections of our constitution. But I think the important point that Hugh made was around appointments. You know, if you appoint correctly and if you appoint right, you'll have fewer of these cases. And so, you know, our Freedom Under Law report and also work by Judges Matter, where we've had a look at, done a retrospective of appointment processes. And then one can look to see, you know, are these the best and brightest people actually making it to get to the JSC, to be interviewed? Is there dampening effect, and are they actually making it to the bench? Now, you know, there's been lots written about that, but I think it's a really important point. And then the last point around Mbex, you talked about Judge Maughan. I mean, we had a webinar that you participated in on judicial conduct, and Open Secrets brought this complaint against Judge Maughan. And, you know, at every, I think it was Unite Behind, sorry. Open Secrets was the Soretti one. But at every, I mean, one of the issues that they were raising, Open Secrets and Unite Behind, was that as complainants, they had to drive the process. They were driving the process in the media to try and get things to move. And as somebody who's written quite in my incarnation at Freedom Under Law, enough letters to the JSC to understand how slow that process, it is snail's pace. And it shouldn't really be the complainant trying to drive it in the media. And, you know, this constant back and forth with Judge Maughan with the state attorney around legal costs. So there are pockets, these areas where reform needs to happen, both within the JSC, and Karyn's point about politicians on the JSC, and reform around the institution itself, you know, and where we stand on that. So I think these are sort of points that need to be highlighted in this conversation.
Mike.
Yes, Hugh.
I'd just like to respond to your initial question about are we facing a flood of these kind of things? And I just want to raise 2 points. One that's already been mentioned to re-emphasize something that Karyn said about judicial leadership. But I'm referring not only to the office of the Chief Justice, but to the office of the Judge President. Now, it's a problem if the Judge President is the problem. I do understand that. But the one of the virtues, and one doesn't always have to throw out the history, but one of the virtues of the past was that the judges president overwhelmingly took their responsibilities very seriously. And when the gossip in the legal profession and among their brethren told the judge president that Judge X or Y was enjoying too much alcohol at public occasions, or wasn't coming to the court on time, or was treating counsel badly or whatever, it would invariably going to have a word in the ear. And frankly, if things didn't improve, the more stricter measures would be taken internally. So judicial leadership is incredibly important. We had some shocking Chief Justices before 1994, and we've had some much better Chief Justices since 1994, but also some rather poor Chief Justices since 1994. And I'll leave you to guess to whom I'm referring to. The second point I just want to make related to this is the whole vexed question of ethics. I'm a retired academic. The question always comes, can you teach ethics? My answer is you can't teach ethics. You can make people aware of ethical dilemmas and things like that. But frankly, you can't test in advance when you're appointing somebody, are they an ethical person or not? They're going to come with their referees' reports, but you can listen to what the leadership of the profession from which they come, whether it be the bar or the academy or the sidebar or whatever. You can listen to what their peers say about them, and you can make a more reliable prediction about whether they're going to be go down the garden path or not, be seduced away from their offices, because it's an incredibly high expectation, rightly, that we have of judges. And so let me stop at that point. Ethics and leadership are critical here, and we have not been well served on either of those counts.
Can I just quickly respond a little bit to what Hugh says on the question of ethics? And part of the example that you made, that in the past, what used to happen is there was a smaller community and people would sort of speak to the leadership and whisper something in their ear, and those issues were able to be resolved in I suppose, using the unwritten rules that are there. The difficulty that we have now is we're in a multicultural society. People have different worldviews. People have different viewpoints. Things that would offend me and my sensibilities based on my background wouldn't necessarily offend you. And which is why it's so important that we start writing down some of these things. And in fact, the Code of Judicial Conduct was introduced. It's the 10th year anniversary of us having a written code of conduct for judges. And in terms of the law, in terms of the JC Act, it has to be reviewed every 5 years. Hasn't been reviewed since it was passed. The difficulty then is, how do you necessarily enforce this code? Because things change quite rapidly. We don't have rules on social media and how judges should use social media, for example. We should be keeping up with times, and this also helps in keeping people honest, because if we have written rules of behavior, sad as I am to say this, but if we have written rules of behavior and we say to people, you need to be paying attention to these kinds of things, I suspect we would see less of the cases that we are seeing now, Mike, because some of these things are quite difficult to handle, because and the constant refrain that Judge Hlophe makes is that he went to the Constitutional Court to just speak, to have a conversation with friends. the JSC said, no, you can't. It's completely inappropriate for you to fly to Johannesburg from Cape Town to discuss a case with people that you were not sitting in the case with. That breaches the ethical rules. And he says, where were they written? And so the response to that is, of course, to say you don't need to be told about some of these things. But I suppose there is a part of me that says, yes, we should actually have some of these things written down and constantly rephrased and re-emphasized, because we need, that's also how to keep people honest. We won't be able to teach people and test them at the beginning of their judicial careers, but we should keep them honest all the time.
I want to also interject here, because one of the people who've been the most consistent on that has actually been the JP, Dunstan and Mlambo.
Mm-hmm.
And Mlambo is actually the person that brought a lot of these complaints against the Makubela, who was also about the Maumela. He was the initiator of all those complaints. So he has walked the talk in terms of not sweeping stuff under the carpet. And when there have been, I mean, even Judge Sadiwala, where he was clearly having medical issues and unable to continue with that trial involving David Mabuza, he said he made the call. He knew it was going to be a drama, but he didn't shy away from it. And in terms of judges that are really aware of the media, but not swayed by them, I think he's remarkable. But he's also someone who, because he's showed a lot of courage, and that bench has showed a lot of courage over the years, he has been, in the most hideous way imaginable, targeted. What happened to him at that Chief Justice interview was a national disgrace. And the fact that it went as far as it did, in the way that it did, to someone who, to come in to say, oh, by the way, I hear that you've been sexually harassing people, but there's no complaint. We don't know who said this. It's just, and this is an interview for the Chief Justice, and that is fine. And only after lunch do we see that being expunged from the record. I mean, that for me is unbelievable. But it was very obvious as someone, and because you were there, they went in, Dahlia Mpofu, Julius Malema, they went in and they wanted to make his life hell in that interview, and they wanted to settle political scores, and they were able to do so. And that's what scares me. And we see this with the David Unterholter example as well. David Unterholter is a genius. You want that man on the bench. We have a desperate need for commercially minded lawyers, people who know international law. But he, every single time he goes there, apart from when he got onto the High Court, he gets targeted with increasingly bizarre complaints, and that is allowed. So at some point you have to kind of go, who's wagging the dog here? What is going on? Because, and I'll wrap this up because I know I'm rabbiting. These people are not here for their own little political agendas. They're here to single-handedly do one of the most important functions in a democracy. And that's to ensure the people who decide who gets custody of a child, who gets convicted of a crime, and who was right and wrong in a massive government decision-making are the best possible people, not your faves, and not the people, and not keep out people you don't like because their intelligence and aptitude and involvement in certain cases makes you unhappy. That's not how it works, and it shouldn't be allowed to continue.
Can I just link that, sorry, Judith, to one of the questions that's come in on the Q&A that asks, can corrupt politicians, and we're not saying anyone is corrupt, but can hypothetical corrupt politicians abuse the well-intended law process to advance their political aspirations? So now we know that we have some politicians serving on the JSC when it comes to the appointment part, the selection and appointment of judges. And then, as Judith alluded to, we have a political context as well at the other end of the whole process in Parliament, which has ultimately to decide whether to recommend in a particular case that the president should remove a judge. So we've got at least two opportunities for corrupt or hypothetically corrupt politicians to interfere. My question is, are our judges and the judiciary as a whole, is it sufficiently insulated from that kind of political interference, or are there urgent things that we need to do to protect them from the corrupt politicians?
I know I've spoken, I'll wrap this up, I'll be very quick. The most terrible one was Judge Matachane. Because it came out during Dunstan and Mlambo's interview that that man, after he said that Jacob Zuma was unlawfully granted medical parole, literally got death threats. And I remember seeing him on the leave to appeal because it was virtual. The guy was shaking. He granted leave to appeal straight away, but he had terror written on his face because people were like, we are going to kill you. And I mean, that for me, no one got arrested, no one got charged, nothing happened. And they get death threats all the time. And Mlambo also said that it happened during the July unrest. I think that's a huge issue. And I think it happens more than we know.
Yeah, it's actually very common. Judge Matojane had to get security at his home. At some point, he had to move out of him and his family had to.
So did Zondo.
Had to move to a safe house. He desperately called us once to ask us to remove his picture on our website because people are using it on social media. And things have settled down, but things are still bad. Last week, there was a case in Durban involving the MK versus ANC over the trademark. The judge specifically told the media that don't take any pictures of me. Don't take any video shots of me because I don't want to be
it's so common.
Subject
it's so common.
of these attacks. And look, this is one way of political manipulation, actually, where judges, where politicians will use the images, will use the identities of judges and post them on social media and say, there's a list going around that these judges are on the CR17 list, and these are judges on the payroll. That list is nonsense, utter rubbish, but it every couple of weeks is recycled and sent out there. And in fact, some members of one political party, I won't mention the name, but they often use this narrative that there's these sealed bank statements. If you actually drill down on the facts, there were no sealed bank statements involving CR17. In fact, one of the political parties that liked talking about sealed bank statements, they were given the bank statements and they agreed to the order to say, for the purposes of the case, we won't publish them. But it is a common thing. And the question is there manipulation that is happening to try and get politicians at least to get their favor in terms of the judges and judiciary? Well, look, people often ask me this, should we remove all of the politicians and the JSC? And I often say, even if we removed all of the members of parliament from the JSC today, we won't stop the politicking that happens, because not all of the politicians are members of parliament, right? There's a difference between a politician and a member of parliament. Some politicians on the JSC come as members of the noble profession. They come as advocates so-and-so, SC, senior counsel so-and-so, but they come there with a political agenda to destabilize that process. And so we need to be quite careful about what we're asking for, because unfortunately, some of the members of parliament say, look, these people often come to us and say, we are the ones people should be looking out for. But if you look at the composition of the JSC, there are about 23 members. 12 of the members are not members of parliament. Members of parliament are only 10. So even if all of the members of parliament voted one way, the lawyers and the judges can completely outvote them quite easily. And in fact, many of the political manipulation that has happened is because of people with legal training trying to manipulate that process in order to achieve their own political ends. One former Minister of Justice was very effective in doing that. He's a trained lawyer, but he consistently politically manipulated it. There's one member who's nominated by the legal profession who consistently uses political manipulation to try and influence the JSC in one way or the other. And so that unfortunately hasn't succeeded as much as I thought he would. There's been one or two cases where he's been successful in sort of delaying the process, but not necessarily getting an outcome that favors him. So the issue of political manipulation, we have to think about it more broadly, because people sometimes do use the politics of the legal profession. And if there were ever politicians in this world, lawyers are the biggest ones. They use the politics of the legal profession to try and influence who gets on and who doesn't get on. So there's also something that we need to be aware of.
Can I just, Karyn, I mean, the earlier point, Karyn, that you made about the Unterhalter matter, the Mlambo matter, I mean, all of this, a lot of it comes down to leadership. And whether it's leadership in Parliament, we get the government we deserve. And so, and those people who are representing us all at the JSE. So, you know, down to leadership by the Chief Justice, you know, of how those interviews, how that is handled. And in that case, very poorly. And I think we need to be able to say that. And so that's one part of it. But the politics can never be taken out of it. All of this is political. We need only look at the United States to see how incredibly toxic that relationship is between the political and the legal. So we can never neutralize it, and we can never take the politics out of it. The question, I think, Mike, you know, your question is, you know, how does one manage it? I think we also have a serious problem within the profession. You know, how do you, who are the individuals who are represented on the JSE, but also within the profession more broadly? These divisions that we speak about, which are replicated, these patterns around the Constitution, around, you know, whether it is a document of white imperial colonialists or whether it is actually our own document which we must protect and defend. That debate is not happening with politicians, but it's also happening within the profession. And we see that laid bare. And so when we have these issues around whether it's Hlophe, Motata, Mbekezeli, it then becomes easy for people who are judges who behave in a way which is very political to exploit those divisions for their own interests. And so therefore to use the race card, for example, or to say, I mean, Beck's your point about we can't teach ethics and Hugh's. No, we can't. But there's certain things, if you are a judge and you're receiving payment, you know, that's not a cultural issue. It reminds me of Dali Mpofu saying in the shut up comment, you know, but I thought I was in the Eastern Cape. You know, that is frankly a nonsense. And so he knows it, we all know it. And yet this theater plays itself out of lies and deception. And so, and at that point, you know, one needs to call it for what it is. So these divisions are ones which are run deep in a society which is actually a constitutional baby. And so, you know, we therefore need to be putting in place guardrails, because as we see in the US and other places, those guardrails, no matter how long they've been there, very easy to knock over.
Last question from me before I open it to the floor. You've raised the question of race, and if we can't keep politics out of these things in South Africa, we certainly can't keep race out of them either. Mbekezeli said to me before we started this evening that a colleague or friend of his, looking at tonight's topic, had said, why didn't you call it impeaching black judges? And that all of the judges that we have mentioned by name this evening, those that have been impeached and those that are under investigation, are black judges. What do we make of that? How do we respond to someone who says this is, to some extent, a race-based thing, that there is some intention behind these impeachment which may be racially motivated? Any of you, and if any of you want to mention the name of Judge Mabel Jansen,
Yes,
you can do that too. All right, you go first.
Fastest case the JSE ever dealt with. Mabel went on a rampage, racist nonsense about, it was rape and it was horrific. She should never have been a judge. But 5 minutes later, homegirl had resigned because the JSE just dealt with it. Because there was, and I think that was for me quite illustrative of what they were capable of when they wanted to get their house in order. But interestingly enough, and Mbekezeli will know this because we went through those court papers, the race issue was played by Hlophe from the very beginning. He said, I'm being targeted because I wrote that racism report on the Western Cape. He accused Dikgang Moseneke, Pius Langa. Dikgang, of course, was jailed on Robben Island of being part of a racist conspiracy against him. Anyone who opposed him or criticized him, whether it was Mlambo and Kabinde, whoever it was put under that veil of a racist plot. He made, and Max du Plessis actually argued this in one of the applications. He said, your culture, the culture is here to accuse the accusers, not to face up and say, and that's the tragedy of Hlophe. If he turned around and said, you know what, I made a hideous mistake here. I should never have said that. I apologize. I will absolutely make myself familiar with ethical, appropriate conduct, etc., he wouldn't have been impeached. He could have rolled it back right at the beginning, but there was some kind of, like, which I think would argue what made him manifestly unfit to be a judge, an inability to self-reflect and say this was thoroughly inappropriate conduct. On the Motata thing, Dali, of course, writes this report that persuades the majority, where he says, based on evidence that actually had been completely rejected by the tribunal, and actually the criminal trial in Motata's matter, that Motata was provoked because of racist conduct from the very person that he was being racist towards. And, you know, what is staggering to me is these are legal professionals who should have been looking at the evidence and saying that's not true. Didn't happen. And then bizarrely, equally bizarrely, he says, even though Motata said, I wasn't drunk, he said, no, you know what? It's okay that he said that thing to that guy because he was drunk. So the whole SCA is like, what do we do? You know, it was a really, but it showed the kind of madness that came from this desire to protect someone and say, you know what? We have real issues in this country. There is racism in the profession. There's racism in all areas of life. Young Black advocates, judges, they face it. They are coming into environments that have obviously been entrenched in white privilege. We acknowledge that, we deal with that. But it cannot be that when we are faced with a confrontation with a situation where someone has clearly done something wrong, that everyone that then accuses them of wrongdoing is branded as a racist. That is highly problematic and it shouldn't be allowed.
Mbekezeli, do you want to add to that?
Oh, I was going to mention that if the tribunal went ahead, the first judge who would have been impeached would have been a white woman.
Yeah,
So,
exactly.
It's not entirely true. It's not true at all, actually, to say that, oh, this is an impeachment process of this or other person. And that's also something that I wish that people would step back. And when we look at institutions, we shouldn't look at it from an individual perspective. Yes, obviously, someone's personal circumstances do matter in sort of assessing their conduct and what kind of punishment can be given. That is often done in these kinds of processes. But we shouldn't start at someone's personal circumstances. We should start at, is there a rule? Did you break the rule? How should the system respond to you breaking the rule? And that kind of thing is how we keep the institution resilient. And which is why I was saying the fact that we now have a system to hold judges accountable, we have a written code of conduct, we have yes, with all its flaws and warts and all, we do have a system that works. We should be focusing on getting the system to work and not starting off by saying, look, because I'm from a village or a township or I'm from Bishop's Court, that I should be treated differently to someone else.
Thanks everyone. Thanks to our sponsoring organizations, Hans Seidel Foundation and the Millennium Trust, my collaborator, Freedom Under Law, and to the 4 panelists for your inputs. I hope you found it worthwhile.